Good afternoon, or at least good afternoon to those of you who are on the East Coast of the United States. My name is Les Strackman. I'm sometimes known as the Second Opinion Evangelist here at Purview. Today's session is a little different than the normal sessions that we've been running in our webinars. Today, this is more of an audience participation session than usual. Your microphones will be open unless you mute them, and you're welcome to mute them if you'd like. We will welcome live comments as well as comments that you type in the Q&A button by the bottom of your screen. When you do raise questions, we expect a level of decorum and just ask you to be kind, whether you agree or disagree with a colleague's comments. We do reserve the right to mute your microphone in the unlikely event that it's necessary. I'm sure that won't be necessary. We're specifically not recording this session to enable you to be a bit more open with your questions and your comments. The topic we're focused on is the interstate licensure of medical providers for the purpose of a second opinion or a patient consult. So first, let me give you a little background on our research, and then we'll get into the questions, and some of those questions have already been asked by the audience in advance. But as I said, we'll also take live questions as we go today. So several months ago, we at Purview participated in an RFP from a major US hospital. We do this pretty regularly, and we're usually pretty good at it. We get invited to the compete, and we often make it to at least the final round. We do pretty well. In this particular compete, we did pretty well. After almost a 6-month effort, we were told informally that we'd been selected as the winner of the award. And we waited, not so patiently, I would say, for another couple of months, and we were finally told there was not going to be any award at all to anybody. When we were granted the debrief at the end by the procurement group, we were informed that the evaluation team for the purchase wasn't able to get comfortable with out-of-state licensure. But they weren't alone. Last month, we were contacted by a gynecological oncologist who was frustrated that her institution in the post-COVID world was not permitting her to deliver her unique expertise to any patients outside of her state. It was pretty inhibiting to her practice. And we heard from doctors in Indiana and in the UC system of California, similar types of things being done in the post-COVID world. So just quickly, a little background on how this all happened. Here in the US, when our nation was originally formed, there were certain compromises that the founding, in this case, it was only fathers, were required to make in order to convince the individual states to participate in this experiment that we now call the United States. One of those compromises they made was the retention of states' rights, basically enabling the states of our union to reserve powers that were not specifically agreed upon to go to the centralized federal government. These had to be, the grants of power to the federal government had to be specifically enumerated in the Constitution and or in its amendments. And one of the powers that was reserved for the states with the power to regulate licenses of professions within each state's borders. And that precept has held pretty fast and true all the way through to today. But with advances that we all are very familiar with in electronic communication, physical borders have been reduced in importance between the states, but the laws still remain. And as we've come through the latest healthcare emergency, COVID, the use of telemedicine has become pretty widespread. During the pandemic, many states relaxed their prohibitions and regulations to ensure the timely delivery of what was then necessary medical care to their citizens. With the federal declaration of emergency now mostly over, most states have reverted back to the enforcement of their pre-existing regulations on out-of-state practice of medicine within their borders, namely physicians who evaluate, treat, or prescribe for patients within their borders, even if it's a patient just passing through the state, they must be licensed in the state in which the patient is currently located. That has created some obviously illogical behaviors and high hurdles for the delivery of telemedicine. Some of you may be familiar with. For example, a patient who gets into his or her car in a suburb of Philadelphia and travels 37 miles to Delaware to consult with a physician there can perfectly legally deal with that physician in Delaware. However, if that same physician answers the telephone when that patient calls from his or her home in Pennsylvania, that physician may be violating the law. Sounds silly. Without changes in our Constitution, our federal government is mostly powerless to change this. There have been some small deviations that have occurred with agencies like the VA permitting physicians licensed in any jurisdiction that's in good standing to deliver medical services to any VA patient anywhere. So far, the VA's powers have not been tested. We're not sure that other agencies like HHS, have the same enabling power to grant similar umbrella permissions for their physicians. Although if they do so, they likely would use reimbursement to influence such a change. Nothing like that's happened yet. So mostly this has been left up to the states. Most states have retained steadfast control over who can practice within their jurisdiction. And this has led to the issue that we faced in that recent procurement. This was so frustrating during that procurement that we decided to dig into the law ourselves. We did a state-by-state review of the very specific language of the laws and the regulations of each of the states, and in fact, territories. There are 54 of them that we researched. But what we found was a bit surprising. In the case of episodic consultations, basically the issuance of a second opinion, the written law is quite different than the practices we've been running into in many of the states. While establishing a continuing or a permanent practice of telemedicine within a state mostly requires that physicians or clinicians be licensed in that state in which the telemedicine is delivered, basically the state where the patient is located. But what we found in the current law is this is just not true for episodic second opinion practices. It's different. It appears that most guidance that providers have been given by their compliance or legal professionals is relying on a telemedicine regulation. And they've not really dug deeply into the language of the law to really understand what is permitted. And we'll talk a little bit more about that today. I understand specifically that lawyers are generally paid to be cautious and be risk averse. However, it's clear that this practice of episodic consultation and second opinions was specifically included in many laws of the states to enable specialists to be consulted to improve outcomes for the patients of the constituents in those states, especially when there's life-threatening illnesses. So let me summarize first by giving you some statistics that we found. 15 states and territories of the 54 specifically permit episodic, occasional, or intermittent opinions to be issued by out-of-state physicians without applying for a license in their state and without having any license within that state. Some of them limit the number of these that a provider can engage in on an annual basis. That's 15 states and territories. 35 states and territories permit the delivery of a specialized opinion as long as it is requested or delivered in consultation with a local licensed physician in that state. Sometimes these are restricted to life-threatening cases, but 35 states have written into their laws that permission. 4 states, only four states and territories specifically restrict this practice. So they say you can't do this. You'll find out that those numbers don't all add up, although those are 54 there, but there's 15 states and territories out of the 54 that are silent on whether this may or may not be permitted. So they don't say that you can't do it, but they also don't say that you can do it, which is issue an episodic or second opinion within their state. We'll talk about what happens in those cases as well. In addition to all of that, many states have joined a consortium of their other colleagues in other states through a consortium called the IMLC. It's now a 5-year-old organization of states who have together created a consolidated reciprocal licensing program among the members. As of last week, there were 39 member states and territories. You can apply once as a provider to get permission to obtain a license in as many member states as you desire. So that could be as many as 39 with one application. The only catch for that is you have to pay the requisite fee and abide by the local requirements in each state. This is great for somebody who's doing this in a permanent fashion, who wants to practice telemedicine on a regular basis within that state. If you're just doing it episodically, this is a little burdensome, and it's also very expensive. The trends, though, in general, are in the right direction. Many states haven't had the time yet to react to change their laws post the federal pandemic and health emergency, but we think that many more states likely will. So that's the backdrop that we found in our research, but I'd like to now open it up, as promised, to any questions that you have in the audience. And again, you can type them into the Q&A button at the bottom of your screen, or you can raise your hand, and I'd be happy to take your question directly. But joining me today to help out with some of the coordination of the questions is Dr. Christopher Schwartz, who's also a member here at Purview. Hey, Chris. And Chris is our evaluator of maladies here at Purview, or our clinical director, whichever you'd like to go by. But thanks for joining us, Chris. And if you wouldn't mind, could you help field some of these questions that are coming in? I see there's some already in the Q&A, and I think you also have received some earlier.
Yeah, of course. So hi, everyone. My name's Chris. So we're going to be, I'm going to be fielding questions from 3 buckets. Some have come in advance. Some are coming in from the audience. And some are questions that we've received from interacting with clients. And the first question that we have is, so Les, whenever you're talking about episodic or occasional encounters across state lines as it pertains to second opinions, is there a specific number of what that constitutes? Like, how many per year does that constitute? And is there a specific limit? And if there is, how would someone find that number?
Yeah, so in certain states, there is a limit. So by the way, the words episodic, intermittent, occasional, those are actually words that come right out of the statutes or the regulations in those states. So I didn't just make those up. Although episodic is a pretty powerful word. I like that one. Yeah, so some of the states actually have a limit, a set limit, and that is a per provider limit, typically per year, annual. So for example, Alabama has a limit of 10 patients per year that you can do as an episodic event without obtaining a license to practice medicine in Alabama. And again, just to make sure everybody understands this, it means you have to be a licensed physician in this case, in good standing in your own home state in order to pass through this, this exception, if you will, to licensure. That's 10 in Alabama. I'm reading the list real quickly just to see the numbers on here. In Delaware, actually, you can come into the state in Delaware 12 times a year to issue an episodic opinion. I'll see if there's any other states here that have numbers like that. There are a few. Tennessee, less than 1 times per month, fewer than 10 patients, or fewer than 1% of your total number of patients in your practice. So it varies a bunch, but there are only 3 or 4 states that have a specific limit. The rest use those words for you to figure out on your own.
Okay. So whenever, from a legal perspective, whenever we refer to, or whenever we say words like episodic, what does that mean legally, and how does that differ from just the like normal or continuous delivery of medical care?
Yeah, it's many of these states statutes actually don't go into the true definition of these words intermittent, episodic, or occasional when they say them. But they mean exactly what they say, which is this is not normal for you to set up a practice which on a regular basis will issue opinions to patients within their state. It needs to be an exception is what they're really referring to. So again, some of them that put numbers on it give you a better definition. So they say occasional means not more than 10 in a year, but you can use that same idea when you think about this. I would say that if you're talking about doing one a week, that's probably not episodic anymore. That's probably on a continuing basis. But it leaves open some interpretation there as well.
Okay. And just to clarify on the first question we asked, are we talking about provider to provider interactions, or are these provider to patient relationships?
So also a really important question. So of the states and territories that we talked about, go back to my statistic, 15 of those specifically do not require that there is another provider in the state that is interacting with that patient in the state. Meaning you don't have to have a local physician involved in 15 of those different territories. It simply can be a duly licensed and in good standing physician in another state that provides a direct episodic consult with a patient in a state in which they're not licensed. So there's 15 specific states that allow that. There are 35, as I said, that do require, and some of those are overlapping. That's why the numbers don't work out. But there are 35 that say, if in fact you're doing this in consultation with a local licensed physician who has the physician-patient relationship already, then you as an out-of-state physician can basically assist in that case by issuing a specialized opinion in conjunction with that local physician. So in that case, you don't have an out-of-state physician with a patient relationship. You have a local physician with the patient relationship and a third-party physician who's entering into that relationship to assist, if you will, and provide their expertise.
And as someone who's taken a deep dive into all of this legal territory, do you see a pattern in terms of how these laws are trending, or have you seen a pattern in how often these laws are changing?
Yeah, so two different questions, I think. I'll unpack them separately at least. So change, it's happening. It's a very dynamic field right now. So what you're seeing is a lot of states are adjusting their generalized telemedicine laws post-pandemic to a new normal. And that new normal takes into account the reality that telemedicine does exist, that patients really like it, and that even physicians are adapting to it these days. So they are being much more realistic about this, as I said, the borders that don't really matter to electronics, but that did matter to us in the physical world that we used to be limited to. So I would say change is the norm, and you're going to see a bunch of change occur. And some of these laws and regulations that I quoted today in terms of statistics are pretty new. But maybe what's most important, at least from a trending point of view, so this is unpacking the first part of your question, is that every state has a medical board, and the medical boards usually are the ones who control who can practice and who can't practice within the state. There's a federation of state medical boards. Basically, it's an organic group of all of the states and territories' medical boards who get together on a regular basis, talk to each other, and talk about what's right and what's wrong. Now, they don't necessarily have to form a consensus. So it's not like this is a voting body, but they do try to come up with things that they think are appropriate for their entire membership. So for all 54 of these. And in last year it was, so in April of 2022, in anticipation of the federal health emergency starting to retreat at that time, they came out with what they call the appropriate use of telemedicine technologies in the practice of medicine. It's a paper. It was a report originally from a subgroup on telemedicine that reported back to the Federation of State Medical Boards. And then it was adopted by the Federation of State Medical Boards House of Delegates. So basically their organizing body. But again, doesn't control the member states. It's simply a recommendation to the member states. But the recommendation is pretty potent. And so I pulled some clauses out of it that I thought were really, really valuable. So there are two in particular with regard to what we're talking about today. The first is, these are their words, the policy does not apply to the use of telemedicine when solely providing, meaning the policy of licensure, when solely providing consulting services to another physician who maintains the physician-patient relationship with the patient, the subject of the consultation. Basically, what these words were intended to say is you don't have to have a license in that state if you're an out-of-state physician in good standing and you're working with a physician in the state to provide this consultation to their patient. So basically, those 35 that we talked about that are already written, the Federation is saying that is absolutely correct, and every state should adopt something just like this. So give a complete exemption if there's a physician-to-physician consult within that state. But in addition to that, they went even further, and they said physicians providing specialty assessments or consultations, and I would say call that a second opinion, if you will, such as a Center for Excellence, are not required to obtain a license in the state where the patient is located in order to screen a patient for acceptance of a referral. Basically, if a physician in the state says, hey, patient A, you should talk to somebody who's a real specialist in this, the out-of-state physician that the patient then may contact for that would be exempt under the Federation's guidance, would be exempted from having to have a license in that state. And then they went further to say the out-of-state physician may provide care via telemedicine using the physician-to-physician consultation in addition to that. And if the out-of-state physician agrees to diagnose, counsel, or treat the patient directly, meaning if a patient says, hey, yeah, Mr. or Doctor, or I guess Mr. Doctor or Miss Doctor, I need you to treat me, and I would like to come to your state to be treated, then that is perfectly legal as well. So continuation of care for that patient to travel out of state to that physician is what the Federation is saying. So the trends are physician to physician completely exempt, centers of excellence, so specialists helping patients who have been told that they need additional expertise, that should be legal as well. So second opinions with or without consult of physicians is something that the Federation is pushing for now.
Okay. Someone from the audience asked us, how does the Interstate Medical Licensure Compact affect or complicate the ability to deliver services? Second opinions.
Yeah. So it's a really important point. And what I would say is it doesn't complicate anything. So it's an additional benefit that is there if a physician, a provider wants to avail themselves of it. What it does is it's single stop licensure. So it is the equivalent of getting licensure in another state without having to take another set of exams, without having to pass additional scrutiny except for one time. So you do a one-time application to the IMLC that enables you, if you'd like to pay the fees, to be completely licensed in the state in which you want, in which you decide you want to pay the fees for. So you can one time pay for, and you can see on your screen now, the states that are in dark blue. Actually, there's a bunch of different levels, if you will, of acceptance of what's happened with the IMLCC. But this will give you absolutely the same privileges as if you were licensed physically licensed in each of those states. So it's in addition to all of these exceptions that we're talking about. So call them parallel processes to help break down these state barriers or borders for licensure. Again, the difference is you probably wouldn't realistically use this for episodic practice of medicine in a state unless you knew you were going to issue your more than occasional opinions in a particular state. Typically, what we found is that the providers that we work with that are doing second opinions, they wouldn't probably use IMLC as their mechanism. They would probably like to rely on the exceptions to the law. It's just a lot easier than anticipating where their next second opinion is going to come from.
So we've been talking a lot about physicians delivering medical services across state lines. What about international second opinions? Does the law speak to, or does state law speak to a physician's ability to offer opinions to foreign patients?
So it doesn't. The laws typically in the jurisdiction are related to patient's location. So if it's a patient that's out of the country, the laws of their country, or their, in case of Canada, the province of their country, or perhaps the state of their country in other countries, controls. So what does that mean? It means that every different country is slightly different. So a couple things that I would suggest if you or your institution is considering international second opinions. The first of which is be sensitive to privacy laws first. So one of the things that's very important and and attempts to be enforced by every country is they want to control where information about a particular patient can be stored or available. So for example, the EU is pretty particular about what patient data, what PHI, or even individual data can be found in the United States, for example. So we have to be really careful about that. Almost every country allows a patient to waive that right. And so if you're going to give a second opinion in a foreign country, make sure that the patient signs something that says it's okay to have their data, their personal information, and their private health information housed in a database, if you will, in the United States. So that's A number one, and that's really a bigger barrier than even the issuance of a second opinion or episodic opinion there. Secondarily, it's going to be very, very hard to track the laws of every different country. But very similarly to what happens in the United States, it is pretty well accepted that if you work with an institution in that country, that you as a specialist can issue a second opinion. You would kind of say in conjunction with a physician local to that patient, you can do that. And so a lot of institutions have informal relationships with other healthcare organizations in the country. They provide specialized opinions and information to them, and that physician-patient relationship is maintained locally in the country. So very similar to the 35 states in the US that do it this way, same thing in foreign countries. The only other thing I would say is from a I'll call it a realistic point of view as opposed to a legalistic point of view, is the sanctions that a country is going to bring against a doctor in the United States for issuing an opinion to help a patient in their country. First, it's very remote that anybody would do anything. But second, they have no standing to do anything in the United States at all anyway. So it's you kind of have some insulation, if you will, from anything that's egregious to occur to you if all you're doing is all you're doing. If in fact you're helping a patient in another country. And I think that's pretty much the norm in terms of what people are considering as they do this. It is a very ripe part of the practice of second opinions these days. There are a lot of institutions in the U.S., many of them are our clients, who have a robust practice of giving second opinions in foreign countries. And in fact, post-COVID, those patients, if they want to avail themselves of what we call a conversion, they want to come to the United States to be treated because there's expertise here in a field that's important to them, they now can travel to do that. So it is something that hospitals should consider if that's if it's something they're considering in terms of second opinions.
So let's bring it back to the states. If a physician is considered in violation of state law, what are the consequences for that?
Well, arguably, if you've done something that is against the law in a state, you could be held liable for breaking the law in that state. A couple of things come to mind right away. So one, physicians are providing an important service to a patient. If you have a patient that's deathly ill in your state, and a specialist from out of state who might uniquely be capable of improving the outcome of that patient breaks the law, it's very unlikely that that state's ever going to take any action against that physician. In fact, for best of our knowledge and our research, it's never happened. So I think this is one of those situations where it may be against the letter of the law, but it very, very unlikely that it would ever be enforced. I had a conversation with the CEO of a group, an organization called Medical Justice, just last week, and he said, "Les, it will never happen." And I said, "Okay, far be it from me to make that decision, but that's somebody who's a lot closer to the situation who said it won't happen." So we've not seen it happen. It seems morally just wrong, and again, the best advice I've got right now is it's probably not going to happen.
For physicians who are thinking about defensive medicine, so to speak, does malpractice insurance speak to the delivery of second opinions? And if it does, will it protect these physicians from legal liability?
So again, I'll unpack that into two different questions. First off, malpractice insurance doesn't necessarily track this question of licensure or lack thereof. However, in our experience, the malpractice insurers typically will step up and work with physicians and institutions, probably easier with larger institutions who have a closer relationship with the malpractice insurance resources that they use. There hasn't been an antagonistic relationship that we've seen when there's the issue of issuing a second opinion in a place which is deemed to be appropriate from a legal point of view of issuing a second opinion. So following these relationships, but they don't work together. So one doesn't necessarily track the other. You need to consult with your medical malpractice insurer just to make sure. Sorry, the second part of your question, I've now forgotten, but I wanted to deal with that separately.
It was will malpractice insurance protect me?
Oh, will it protect you? So the answer is it won't protect you from breaking the law. So if we go back to the, are you licensed and did you break the law in that state? If for some reason the remote situation that a state takes action, your malpractice insurance doesn't deal with that. Your malpractice insurance is for other purposes, which is effectively just to ensure that you are protected in what you're doing in terms of the practice of medicine, but not the breaking of the law, if you will.
Okay. So someone just wrote in, like for a state like Indiana, how would a physician-to-physician consult work via second opinion, and how would you recommend a neighboring state or any other state in the union approaching Indiana?
Yeah, so it's a good question, because Indiana is one of those states that's actually silent on whether this is something you can prescriptively do or can't prescriptively do. So here's the way that I would approach it. So one, I think it's pretty clear that if a state is silent, they haven't prohibited this practice. I would recommend that you ensure that you have a relationship, a consult, including a local physician that has a patient-physician relationship established in Indiana in this case. And then I would feel comfortable having you issue a second opinion in consultation with or conjunction with that local physician, because it's not prohibited today. Again, relying on the fact that this is important for the outcome of the patient. Now, with that said, you may have seen a screen in the beginning of this show that said all the legal disclaimer stuff. So I'm not telling you to go do it. I'm not telling you you'll get away scot-free by doing it. I just think that this is the trend and this is the likelihood of doing it. But I would consult with your legal counsel or whoever provides you with that advice in your organization and ensure that they agree with what we're saying.
So, to your knowledge, is there any legislation on the state or the federal level that's currently going through the legislatures that could impact your current interpretation of the law?
So there is. I can't cite it to you in each state today, but there's a lot of the wheels are turning, as we talked about before. Change is at hand in many of these states. So there's legislation that's been proposed. There's even federal legislation that's been proposed that so far hasn't gotten much traction, but there's legislation that has been proposed in a bunch of different states that either will or won't make it through the legislature, that either will or won't make it past the governor's desk. And those kinds of things are going to change. Again, we think the trends are in the right direction. So I'm guessing, at least on average, it's going to get easier and better to deliver these episodic opinions in more states than perhaps there are permitted today. And second, those changes will occur, and we try to stay up to speed on them. I think the last review that we did was just under a month ago. But these laws, there is no schedule, there's no calendar for when these laws change in the various states. So you do have to keep up to speed with them on a regular basis. Somebody needs to be doing that review. We're going to continue to publish what we do. And we have that really cool map that was shown up on the screen before, which is an interactive map. You can actually get to that map, I think, on our website. But if you click on each of the states, it gives you basically a rating as to whether, based upon our review, there it is, whether based upon our review, you can get a permit, or you can be permitted to do either a consultation or an episodic without a local physician, without running afoul of the law. Thanks for putting that back up again.
One question that is interesting is some institutions deliver remote second opinions and refer to them as they are educating patients, and then other institutions refer to them as physician-to-physician consults. Can you walk us through the difference between those two tracks legally?
Yeah. So it's really a specific matter of how the statutes are worded, really, more than anything else. The vast majority of the statutes do not include exemptions to licensure based upon the words education of the patient. It just doesn't have it. Doesn't mean that it's wrong. It doesn't mean that's not a good approach to protecting yourself when you issue a second opinion in a state in which you're not licensed. However, the law doesn't say those words. I really prefer the physician-to-physician consult, because 35 of those states and territories actually have those words built into their statute, and those words will protect you. So in 35 states, you got your badge, you can go do it if you do a physician-to-physician consult, according to the specifics of that statute in that state. But there isn't the same in terms of language on education. So if I were going to give you advice, I would say use the physician-to-physician consult as a more specific exemption to the licensure regulation, and you'll be in better shape.
So for all of us non lawyers who work at academic centers who are trying to convince our lawyers to let us provide second opinions across state lines, do you have any recommendations for strategies to strategies or resources or information to help convince these lawyers to adopt this practice?
Yeah, and yes, I do, and I don't actually think it's an antagonistic situation. I think it's just provide the data, in this case, the language of the laws, regulations, very specifically related to episodic, occasional, or intermittent practice to them, and have them form their own opinions. The lawyers that I've run into in these medical institutions are good. They know what they're doing. I think the only thing that's been missing is they've gone down this path. We've been lulled into viewing episodic kinds of consults similar to telemedicine. And it's way tougher to establish a telemedicine relationship in these states in which you're not licensed than it is to do this episodic stuff. So if we show them the language, and I have citations built in, well, they're not available on that map, but we have them here that we base all of our decisions on. We've got citations to this very specific laws and regulations, and sometimes proclamations from the medical boards in each state, and we can simply show it to them, and then they can make their own decisions based upon that. And I'm not 100%, but I'm pretty much 99% confident that they'll agree exactly with what we've said. Because again, we're not asking for interpretation of law. We're simply asking for review of the law. And I think the review will turn out exactly the way we say.
And if I'm a lawyer or an interested physician, where do I go to keep track of, how do I keep track of this topic?
There's a lot of good resources, and you'll see, and I know we're just about out of time now, so you'll see on the last screen that we put up some direction to some citations, which I think we can provide you as well. But the FSMB that I referred to earlier has some great stuff, and it's pretty darn clear, even though it's written by lawyers, I'm told. It's pretty clear that you can follow. So there's there you can see on the screen, there's the appropriate use of telemedicine technology. That's the study that I referred to earlier. There's the Telemedicine Policies Board. That's very good. And in addition to all that, if you have very specific questions about a state or about how you can do this in your institution, you can just contact us, and we'd be happy to do a consult with you, and free of charge, just to give you some information on what we know. Again, it's a snapshot, so things are changing, but we'll tell you what we know up to the current time. And if that helps you going forward, we'd be happy to do that as well.
Okay.
All right, Chris, I think we're either out of questions or we're out of time, one of the two. But thanks so much for your help today, Chris. I appreciate you being an intermediary with all the questions that have been raised. Thanks again to those of you in the audience who have listened through this. This hasn't been recorded, but again, we'll be happy to do follow-ups if you have specific questions, so you can get your questions answered. Thanks to Samantha Winters, who has been behind the scenes taking care of all this and posting all those wonderful screens for you. And that information, again, is going to be available on our website. So we're looking forward to helping you if we can. Other than that, have a great remainder of your day, wherever you happen to be. Take care.